Feeling it now?
Shall we start now?
Yes, madam, I am ready.
Good afternoon, everyone. I welcome you all to the webinar of ICSI IIP on the topic Anatomy of IBC Case Laws 12. Today we have with us Mr. Siva Prasad Pulva as faculty. Let me introduce Siva Prasad sir. Sir is a qualified professional in cost accountancy, company secretary, finance, commerce, insurance and banking. He is having experience of 36 years in banking and financial services with cross-cultural experience and good knowledge in the insurance sector. He has handled senior level responsible positions with higher level interactions and exposures. He has authored for a number of books, study material for the professional institutes like ICSI, ICAI, ICMI, IGNU, IIBF, Insurance Institute of India, Mumbai, etc. Now over to you, sir. Please start the session.
Thank you very much, madam. Thank you very much for ICSI, IPA, for giving an opportunity to discuss about anatomy of IBC case laws 12. First of all, I wish you all the best in the new year. Happy and prosperous new year 2024. And I wish you all the best in your professional front also. And as I told madam, I'm the former assistant general manager of State Bank of India. I'm also insolvency professional. I'm handling some cases also. I belong to Andhra Pradesh. Now I am at Hyderabad. And whatever the recent judicial pronouncements are there, up to 5 o'clock, I will discuss about the judicial pronouncements, particularly the 5 or 4 judicial pronouncement in detail. So judicial pronouncement 1. I will discuss about the judicial pronouncement 1. Aquacity home buyers and Madhya Pradesh RERA got landmark order against Akriti Group and DB Corporation. Sir, today the real estate sector is booming like anything. Being a banker, I know how much loans we are giving to the individual loans as well as the corporate loans, particularly for the real estate sector. And on account of pandemic COVID-19, still some of the real estate builders, they are facing problem, and the liquidity problem is also there. And some of the cases are filed with NCLT also across the country by my bank also. So that's why this is the opportunity to get that cases, not only that opportunity, in most of the real estate sector, lot of malpractices are also happening. The malpractices create a lot of problems to the home loan buyers. So whenever I am taking a loan from the home loan builder, he will hand over the house after 2 years or 3 years, depending upon the speed of the construction and etc. etc. Virtually speaking, banks are not giving any loans to the real estate. And whatever the initial capital are there, and whatever the loans, the installments are disbursed by the bank, with that installments only the construction activity they are completing. And across the country, the home loan buyers are facing some problem on account of malpractices of some of the builders. This is the case. This case is also on that particular how the home loan borrowers, buyers are facing a lot of a problem on account of malpractices of the builders, that too real estate builders. Even the RERA Act is there. Some other states they have implemented, some other states still in the process of implementation, some other states are already implemented, and they are the regulators for the real estate. But still, whatever the bad practices, whatever the malpractices, still it is continued. This is Aqua City home buyers and Madhya Pradesh RERA get a landmark order against Akriti Group of and a DB Corporation. It is a significant development of the NCLA delivered a landmark order on December 2023 in favor of the Aqua City Consumer Social Welfare Society and the Madhya Pradesh regulatory, particularly the real estate regulatory authority. This is a victory of represents a ray hope of the home loan buyers. Being a banker, I know some of the home loan borrowers, they wish to purchase, but the possession of the home they are giving after 5 years, even though they are telling that after 2 years the project will be completed. And if at all a delay has happened, per month we will pay 10,000 or 15,000 rent. All these things on the paper only it is there, but in a real sense that is missing. And a rare hope for the homeowner who have been entangled in the legal battle. They struggled a lot. One side it is a non-performing. Second side they are not occupied the houses. Third side interest accrued. All these things, a liquidity problem for the individuals on account of a wrong step made by them while purchasing the home loans. Builders across India fighting for their hard-earned savings. The customers are the individuals, not a corporates. And thereby the individuals are suffering. They want to enter into the dream home, that dream home that is not happening. That a dream is not happening in some other cases. Now I will discuss about how the Supreme Court viewed this Akruti, particularly the Aqua City home buyers. They will give the big advertisements, shaping the happiness. Like that, they will use whatever the marketing techniques are there. They are using, and some of the people only, not all the people. They are cheating the home loan borrowers, buyers also. This is the brochure they have published while mobilizing the business from the prospective home loan buyers. So they are giving the color and the greenery, all these things. In reality, that is a different one. This is the shape of the project. So at the time of selling the project, this is a brochure, and the present situation of the project is this is one. But if at all I take a salary or a loan taken from the bank and invested in home loan, if at all I am not getting the fruits of that particular investment, then it is a mental agony and torture. All these things are there. Now coming to, after going through this particular case study, that is Supreme Court of India's case study, the key learnings are: read the complete application form submitted by the financial creditor. Being a insolvency profession, at the time of application, whether it is a section 7 or 9 or 10 submitted to the NCLT, we have to get the copy. We have to read the how they have filed, what is the reason for filing of the case, what is the default amount, how the default, all these things are available. Because some of the people, they are eager to take the particular order from NCLT, allotment order. But beyond allotment order, what is the application made by the financial creditor or operational creditor or corporate data, and the financial creditor, corporate data, by the resolution profession after allotting the case by the NCLT or getting the order from the NCLT. That is a prerequisite. Because whenever I am handling the case, first I will go through what is the problem in this case, who is the defaulter, and how the default was happened, what is the current default. All these things are to be verified with the papers that is submitted to the adjudicating authority. Read the NCLT order completely before starting the process of CAR. We have to read. completely, thoroughly. And whatever the latest regulation that is uploaded in IBBI, that is also to be downloaded to handle the case. Because one beauty is there in IBBA. Whatever the regulations, updated regulation, from time to time, they are uploading. And what are the current, as on date of commencement of, as on date of admitting the case, whatever the regulation is there, take that regulation. Verify the claims thoroughly. This is one of the gray area. Because I am observing some of the people, particularly some of the RPs or IRPs, they are not thoroughly verifying the claims with the available records, with the available IT system. Suppose in most of the cases, what is happening today? Most of the records are in technology, that is a computer system, that is RAM, random access memory. So whenever we are taking the matter, particularly the case, we have to ask the user ID and password and disable the user ID passwords of others. Otherwise, there is a probability, there is a possibility for changing that user ID and password. Verify the claims thoroughly before admitting the claims. What is the books of records? What is a document I have submitted? Whether it is a time barred or not, as per the Limitation Act, section 18 or 19. Section 18 is the acknowledgement update. Section 19 is part payment update. Whether the documents are live or not, that is to be verified. Once you have verified, later on, the subsequent problems will not arise. Fraudulent claims are also. Once the company is under CIRP and the suspended directors are not access or getting the information, particularly for the company records, and some of the unscrupulous persons, they are filing the wrong claims also. Further investigation is also required. The purpose of the transactional auditor is to verify the PUF transactions, particularly 1 year look back period and non-related, related 2 years back, and the fraudulent transaction look back is no period. So the appointment of a transaction auditor also qualitative one. Because some of the people on a episode manner, they will appoint the transaction audit, whether he is having a good knowledge in forensic audit. As per IBC code, transaction audit is not defined. There is no qualification, nothing. But even some of the people that are talking about forensic, it is not a forensic audit. It is purely a transaction audit. Forensic audit word is not there in IBC code. So the PUF transactions of the corporate data, that is to be verified. And based on the experience, based on the cases, the PUF transaction list is also increasing day by day. And in some the pronouncements also they are adding. This is also comes under profession. This is also comes under undervalue. This is also comes under extortion and fraudulent transaction. Various agreements. That is also very important. Whatever the litigations are there in the company, we have to verify. While issuing the information memoranda, we have to give it is as good as a prospectus. Being a company secretaries or advocates, most of the people they know. While issuing the share capital, we are issuing the initial public offer, we are issuing the prospectus by the companies or abridged prospectus. That information memoranda is about the marketing document, about the transparency of the real facts of the case. While giving the information, what are the agreements, what are the litigations? That is also to be mentioned. Then only the prospective resolution applicants, while submitting the resolution plan, you should aware the nuts and bolts of the total system of the company. Various agreements reached by the corporate data which are pending at the time of CIRP has to study by ROP thoroughly. Agreements. If at all I have not read the agreements and some of the agreements, the conditions or covenants, later on it create a problem. Legal suits are filed against the corporate debtor, and the degree copies of the judgment of various courts ought to be studied properly. Then only we can do the justice to that particular profession. This is the role of IBS, the IP or resolution profession. So this is the clear learnings, because I'm going to discuss the case. Before that, once you read the cases, some missings are there in that particular role or functions of the or responsibilities of the IRP or RP. Follow the code of conduct. Being an IP, I have to strictly, the code of conduct is also latest, whatever the insolvency professional code of conduct regulations are defined by Insolvency and Bankruptcy Board of India, that is to be uploaded and have a look. And whenever you are discharging your duties, once or twice, whether I am following the all the instructions that are issued by the IBBA or not. From time to time, follow the Limitation Act. Every debt, even as a banker, our role is once the loan is taken, after 3 years, the documents are in live or time barred. If at all documents are going to be time barred, I have to take the acknowledgement of debt. So that's why Limitation Act 18 and 19, we are thoroughly following. The same is to be followed by others also. Otherwise, the debt will become time barred. Once the debt is a time barred, you need not admit as a claim, because 3 years completed, any acknowledgement of debt is there or any part payment of that particular debt is there. Show me the evidence, then only I will admit. Follow the Limitation Act. From various security documents executed by the corporate debtor during the course of the business, and who are pending at the time of CAR. So that's why the Limitation Act is very important. Now, these are the key learnings in this case. Real Estate Regulatory Authority and the DB Corporation Limited and others neglect New Delhi branch. That is the 8th December 2023. So once you go through this one, then automatically whatever my key learnings are there, all are covered in this particular case. That's right. Whenever I'm reading or whenever I'm going through any case study, what are the key learnings on the case study? Now coming to on 19th, I will discuss about the case in detail. After that, what are the malpractices that are happened in that particular case study? Definitely, we will analyze and what precautions we have to take. All these things we will discuss that. On 9th December 2023, the National Company Law Appellate Tribunal delivered a landmark order in favor of an Aqua City Consumer and Social Welfare Society, which represent a group of home loan buyers. Government is giving a lot of importance to the housing sector. Housing sector boosts the economy, because once the housing sector is increased or developed, growth year on year basis, combined annual growth is increased, then automatically on account of real estate sector, cement industry, or the labor, they will get the employment, or the steel industry, or the paints and whatever the electronic like fans or all industries growth will that is called a derived demand. That's why the government is also giving a lot of importance. That's why the real estate sector is booming year on year basis. Real estate builders are also increasing. New builders are also entering into the field. But ultimately, they should not give any inconvenience to the hard-earned money invested by the home loan buyers, which represents the group of home loan buyers. and Madhya Pradesh RERA Act. First time the RERA of MP also involved in this case. They are also filed against that particular real estate owner. These people are doing wrong things. They are siphoning the funds. They are doing the wrong things. All these things are there. So that is in this case, first time the RERA of Madhya Pradesh also involved in this case. The homeland buyers will hopefully get a refund of their investment with interest from the Akruti, even if they had given up on homes they had invested in. Some of the they vexed with the particular builder. Some of the home loan buyers they give the refund. Why don't require your home, your the flat? The home loan buyers are will get the refund. They are always how long these people will take. One side, the banker has demanding for the repayment and accrued interest year on year, month on month basis. The interest is there. And once the account is turned into bad, the individual's CIBIL rate will also damage. Credit Information Bureau of India Limited, without a fault of the particular the home loan buyer. Once the builder is delayed, the bank loan repayment will be delayed. And once they delayed, then automatically he will, his CIBIL report will be damaged. Once the CIBIL report damaged, in future he will not have get any loans from any banks on account of delay in payment of their taken loans. This is a long and harrowing battle, almost 30 years. The home loan buyers with this Akruti, they struggled for 13 years. Imagine how much humiliation. So whenever we are taking any particularly any case, who are the stakeholders? We have to satisfy all the stakeholders in CIRP process. Not the financial creditors, not the operational creditors, not the staff, or all people I have to do. That's why the stakeholders is a broader term. 13 years may not have ended yet because there's still an option for the powerful corporates involved in the approach of a Supreme Court to delay the justice. They are using the shelter and thereby the sufferers are. That's why the Minister of Corporate Affairs, they wrote a letter to the Minister of Finance. A separate CIRP process is required for the real estate sector. Suppose if the real estate sector, 10 ventures are there. Out of 10 ventures, one venture is problem, remaining 9 is stopped, then automatically the 9 people, each venture, 2,000 to 3,000 houses means all people will struggle. Shortly, they are going to introduce one more model, particularly for the real estate sector. The tailor-made CIRP is required for real estate sector. But it holds the important lessons for thousands of home loan buyers involved in similar murky battles against the builders across India over a significant chunk of their life savings. That's why definitely in the coming days, most of the loans are turning into bad. This is my guess. Being a banker, my guess is real estate sector, they are facing a lot of problems. Some of the accounts are non-performing, they turn into non-performing assets also. So that's why they being a professional, you have to understand the sector-wise the information. You have to extract that information. A positive aspect of the long road to victory was that MP RERA was the first time fought alongside the home loan buyers. Normally, RERA, I have seen so many cases, they have not involved. They are the spectators only, how the things are happening like that. They are, for the first time, Madhya Pradesh RERA first fought alongside with the home loan buyers and had weight to their standard, and bankruptcy law was wrongly invoked. So that's why The regulator should also give the support. Once the support is given, then automatically the beneficiaries are the home loan buyers. Members of the Aqua City Consumer Firm purchased a residential apartment in 2011-2017 period from AG8 Venture Limited, which is a part of large business group with interest in real estate sector, hospitality sector, sugar and healthcare. Today, what is happening is the the parent company and the subsidiary company diversion is happening. Funds are diversion from one company to another company. Thereby, it is very difficult for the IP also. I have seen in Hyderabad also. Now I am giving some suggestions to one unit, particularly the real estate sector. The funds they are receiving from the home loan buyers, diversion. So this AG8 Ventures Limited, which is a part of large business group in the interest of real estate sector, hospitality, sugar and healthcare. Its real estate projects spread across the country. And the brand name is Akrit. It has a large presence in Madhya Pradesh with 11 registered with MP RERA. And shortly during this year, most probably before June, another amendment will come. A tailor-made CARP for real estate sector. That is a need of our. Otherwise, thousands of the home loan buyers are suffering a lot on account of the CARP process of the builders. When the builders was unable to deliver the apartments, the Home Loan Buyers Association moved to National Consumer Dispute Resolution. Because the builders, even a CARP is also costly for them. They have to appoint. And the long process, admission and a lot of legal battle, all these things are. Consumer firms are located almost in every district and every state consumer firm or national consumer firms are there. They are also quickly disposed of the cases. That's why to get the instant justice, the home loan buyers are approached the National Consumer Disputes Resolution Commission and obtained a favorable order 2021. After a long time of 12 years, they got that favorable order. And they established that Messrs. Akriti has diverted money meant for the project. Today, most of the corporates, the end use of funds is a question mark. In most of the corporates, end use, whenever they are getting some funds, that the funds are not utilized for the purpose they have borrowed. Once that is they not used, it is nothing but a diversion of funds. So that's why bankers' objective is ensure the end use of funds. They establish, particularly the home loan buyers in the consumer commission, they established that the Akriti diverted the money meant for the project. Okay. The Apex Consumer Firm ordered the builder, AG8 Ventures, to refund their money from the date of possession with 9% interest. Once the home loan buyers are purchased the homes from the date of purchase, the interest should be paid from the date of sale agreement. Sale agreement date. Normally, possession will happen after 2 years or 3 years in long-term ventures. But here, the Consumer Commission, they have given a data for possession with 9%, not it from the data for purchase. Purchase to possession, normally it will take 2 to 3 years. In that meantime, the banks will calculate the interest. The bankers will calculate the interest. And who will bear that particular interest? If at all the diversion of funds are happen, who will bear that 3 years interest? That to penalty, that to spoil of a civil report, all these things are there. However, order was flawed. After all the money ought to be refunded with interest from the investment date and not from the date of possession. I have purchased one flat in one builder in Hyderabad. After 3 years only, they have given the possession. And 3 years, the total amount they have required. Every time, whenever I am going to visit to that builder's premises, your flat will come on that particular 18th floor. At that time, on 18th floor, nothing is there. And after three years only, I have seen the 18th floor. At the end of the normally 3 to 4 months before only, I have seen the 18th floor. Till that date, I have seen the sky on. However, the order was flawed. After the money ought to have been refunded with interest from the investment data, not from the data position. Every home loan buyers, okay, we got the favorable order. That favorable order is also some problem is there. Not from the data position, from the date of investment. So they approached the Supreme Court for modification of the order given by the Consumer Commission and obtained a verdict in favor in October 2020. They got the order. Verdict in their favor. Modification of order. Whatever the modification order they got on October 22, they approached the Supreme Court. Sir, we got the order, we got the favorable order only, but some modification is required. Modification means not from the data position, from the date of investment made by us. In August 2021, Madhya Pradesh RERA has also passed an order against the builder after it was established and failed to maintain the money collected from the whole loan buyers. The being a regulator for the real estate sector, they have also closely verified the books of accounts of the particular real estate sector, the promoters, and whatever the funds they have collected from the home loan buyers, diversion in a separate designated account. They have to open separate designated based on the construction. They have to withdraw and spend that amount for the purpose of construction only. But they are violated that one and instead diverted the money to other projects. Project-wise accounts have to be opened. And whatever the home loan borrowers installments are there, that is to be deposited, that funds are to be utilized for that project, not for the other projects. Not for the other projects. But what he did is he used that funds for other projects. MP RERA ordered the detailed investigation into finances of the builder and appointed Milind Vaikor financial advisor, who was keep the regulator informed about the findings and developments of that particular builder, how the funds are received, how the funds are diverted to other projects, and how much funds are used for this project, all these things. Subsequently, based on the findings of the registration of Akruti Aqua City and Akruti Business Arcade was cancelled in 2022. RERA Madhya Pradesh, they have cancelled that particular registration. And the agents was appointed to complete the project. They have appointed one agency to complete it. Then problems are started. They have appointed one agency. Funds are required. Some funds are diverted. And one side is the home loan buyers are unhappy and they are struggled a lot to get the finance from the bankers. All these things are there. The builder, meanwhile, used every legal form to challenge the orders. Normally, the builders, whenever this time, even CIRP also, most of the builders, they are unhappy. Because once the case is admitted, then automatically their powers are suspended and they should not be in the office. The IRP will become the CEO of the company and entered into collusive deal with the TB corporation. They are finding out the ways and means how to again enter into that particular company. Dainik Bhaskar Group, one media company is there. They have entered a collusive deal. This is not a genuine deal. Collusive deal with Dainik Bhaskar Group, one of the largest newspaper in Madhya Pradesh, a listed company to a deadlock action. A listed company to deadlock action. The deadlock, what is the deadlock? Deadlock is particularly this Akriti has given to another person and he has to construct the activity not by the Akriti and whatever the Supreme Court judgment, particularly the consumer firm, they have given the judgment. According to the judgment, that amount is to be paid. All these things are there. That's why the builder is again searching for way out how to overcome this problem. And he used the Dainik Bhaskar Group, a media company. In January 2022, a Dainik Bhaskar Group company invoked proceedings under Section 9 of the bankruptcy law. He is telling that I am the operational creator of the particular Akrit. I am the media company. I have given wide publicity for their projects and they have due for this much amount. And I am the operator. To overcome the problem of the consumer court decision, the builder is approached the DB Group. And once IBC is there, all whatever the earlier the particular judgments, all these are null and void, and the IP will the IBC will prevail over the other acts. So in January 2022, the DB Group invoked the proceedings under the Section 9 of the bankruptcy law, claiming that he is operational creditor and he had paid to be paid 10.77 crores, including interest and the barter agreement with the builder. This is created. The real estate people, they are using this type of tactics. So one side, CIRP is the best for stakeholders. Second side, CIRP is also used as a tool by the corporate data for doing wrong things. So the barter agreement with a barter agreement, what is a barter agreement? I'm giving the media advertisements and for each and every advertisement, you give me allotment of one flat in your project. That is a barter agreement. And only 10% you pay the amount, remaining 90% you allot me one flat. That is a barter agreement between the Akriti as well as the DB corporation. Okay, once that amount to be paid by they have created, And they created means, and he is claiming that I am an operational creator. I have given wide publicity advertisement, this much positive that amount to be paid by the Akriti. And for that, I'm the operational creator. I'm filing under section 9 of the Act. It transpires that AG8 Ventures had entered barter agreement with the DB Corporation for nearly 10 years. Between 2010 to 2009 for massive advertisement deals. Today, even in I'm seeing in Hyderabad also, particularly Enadu or other newspapers, big advertisements. The media also, once they are giving publicity to the real estate, they are getting some flats with low rates from the builders, and they need not to pay the amount. In turn, they are getting some flats in that particular way. That flats they are selling to the others with a high amount. This type of malpractices are also happening in the real estate sector, particularly the builders. It transmits that Agent 8 venture had entered into the partner agreement with the DB Corporation. Nearly 10 years between 2010 and 2019, massive advertisement details. Daily it will come, or every 3 days, one advertisement in different angles, and with the ecosystem and all these things, greenery and all these things nearest to that particular IT corridor or pharma city like that, or the outer ring road, all these things they will give in a beautiful manner to attract more number of home loan buyers. Such deals allow real companies to buy expensive and prominent advertisement space in leading newspaper. It is common for the past 15 years. Today, the real estate is growing on account of marketing techniques. Once you are entered, they will create one model house. In that model house, whatever the latest updated the items are there, all particularly the people who are visited, wife and husband, they tempted to purchase that. Second side, the advertisements. This is happening for the last 15 years. Under such agreements, the reality companies make a small cash payment to the media, that is a Dainik corporation, for advertisement and allot house units. That's why it is called a barter system. To the media houses for the rest of it. The media, in turn, they will sell the same to the others with market rates. They are getting the flats with the cheaper by giving the advertisement from the newspapers, and they are getting the flats with the cheaper rates when compared to the rates offered to the public. And these two people, they are trying to cheat the home loan buyers. Under such agreement, reality company makes small cash payment for advertisement and allot housing units to the media for the rest of it. Under 9 agreements with the DB Corporation or Dainik Bhaskar Group, Akriti already handed over 20 residential units. So 20 residential units for paper given media for printing of the buildings, the decoration, all these things, cars and the swimming pool, all nearest to the metro, all these things to DB Group, and battle with the 19 more to be remained undelivered. It is artificially created. It is fabricated by the corporate data by taking into account of the DB Corporation. Some people they advise, why you are worried, boss? Don't worry about the consumer firm's decision. If at all IBC is there, definitely all the consumer firms or Surface Act, all are prevail, the IBC will prevail over the tax. Somebody has given sanctions to the corporators and the residential units to the debit group, and the battle was 19 more remained undelivered. For readers, particularly those who are reading the newspapers, who think that a full page advertisement campaign suggests financial strength of the builder. Once a massive advertisement with the colorful photographs on a daily basis, if at all they have given on paper, definitely people will believe and people will tempt to buy that one. Just one particular advertisement commitment is 25.50 lakhs. Akriti Biller pay only 2 lakhs in cash. Remaining is one flat. While rest would be paid allocating residential units. This is a practice. This is a practice that they have followed to cheat the home loan buyers. Today that is happening. Because in Hyderabad also, one builder is there. Whatever the home loan buyers installments are there, he collected and invested in one political party to get the MLA seat. That MLA, he is not own that particular seat and simply keep quiet. Today, 2,000 people, they struggled a lot. They are not getting money. Banker is one side, they are sending notices. All these things are there. So just one particular advertisement committed 25.50 lakh, offer the biller insignificant, that is 2 lakhs remaining one flat. There were 9 such agreements adding 14.36 crores. And the cash component is only 2 crores. It is important to note that bankrupt law is invoke list moratorium on our claims. That is the suggestion given by some people. That's why that suggestion is properly implemented by the Akriti. Moratorium on all claims. That's why you create one operational creditor, and with the help of the operational creditor, you file the application with NCLT. They will admit the case. Then you need not pay the 9% from the date of allotment to the home loan buyers. That type of sanctions some people has. Hence, the orders of the consumer courts, RERA also penalty imposed. To overcome that particular problem, they have fabricated that particular cannot be executed against the builder. MP RERA argued before NCLT that DB was not an operational creditor. He is merely given advertisements. Out of the advertisement, 2 lakhs and odd for advertisement he has taken. For that allotment is also given. And could not invoke the insolvency law. Sir, don't invoke the insolvency law for this Akriti. And it has done in collusion with the builder. The DB group and the builder is colluded. If at all you are admitted the case, then automatically the sufferers of the home loan buyers. MP RERA. First time RERA also argued from the side of the home loan buyers. In this case, with NCLT. As an side, Indian bankers still settle respective rights and actions of consumer firm, sectorial regulator, RERA, and security. Still okay. Even though IBC prevail over all the acts, still IBC is also respected the other laws. In most of the cases, a variety of conflicting judgment has been invoked by creditors to back their case. There are that variety of cases are coming. During the bankruptcy proceedings, Akriti said It is already paid cash component under the barter deal. As a DB corporate demand the builder said it could only pay the principal amount of 5.25 crores, but not interest. Only for interest component only the operational creditor filed an application with the NCLT. The principal amount is paid and the balance amount they have allotted the houses, but only the interest portion. This is fabricated. Fabricated that builder included with the operational creditor, they have created the scene during hearings of NCLAT, noted on the basis of which DB Corporation already has converted its right into allotted 19 apartment into very specific sum was not clear. 19 apartments are already given by the Akruti. That is also converted. The consideration amount is not specifically revealed in that particular sale contract. As the battle progress, further suspicious deal value is revealed. Once you are deepening into that particular case, definitely what is the bad intention of the corporate data, what is the bad intention of the operational creator, all definitely it will come out. M. Pereira told NCLAT, DB Corporation itself is a collusive action aimed at twisting out of the obligation arise out of the reality regulators various orders. Collusive action aiming twisting out of the obligation various orders. One side RERA has punished the builder. Second side consumer firm also awarded the order. All these things are to be fulfilled by the builder, that is corporate data. It was argued that the barter agreements to pay a lavish expenditure, advertisements, themselves disapproved by the reality regulator. Whatever the barter system reached by the DB group as well as the Akruti, that is not approved by the RERA also. And debatable whether media house could be possession of operational creditor or not, with a claim superior than the home buyers, superior to that of the home buyers. Then question is asked, whether media house could position itself in the operational creditor with a claim superior to that of home buyers or not. That is the question mark. That is the crux of the issue, crux of the case. Mrs. Akruti home buyers were able to obtain certified copies of documents submitted before NCLT, indoor, and analyze established of the invoice submitted by the DB. So for everything, DB group has to be submitted invoice. That invoice they have to pay either amount or allotment of the home, the flats. In support of the claims, forged and fabricated. All documents are, invoices are created by both the DB group, the operational creditor, and the corporate data. They have fabricated, they have created that invoice. Why? RERA is imposed some penalty, consumer firm given the order to pay certain amount of interest from the data position to the home loan buyers. They have created the forged documents, fabricated documents. And NCLAT order notes that goods and service tax come into force in 2017. Everybody knows about that one. But in invoice, the column in the GST column was mentioned 2010, had columns and GST printed on them. Goods and Invoices Act is started in 2017. But whatever the 250 invoices raised by the DB group For in the past, from 2010 onwards, the GST column is there. How they forecasted that the GST will come in 2017? So it is a fabricated. It is a forged documents, forged invoice, that too raised by the operational creditor. That too not properly verified by the IRP, not properly verified by the particular transactional auditor. That's why whenever the claims are admitted, whether it is a genuine claim or not, whether it is tallied with the books of available books of accounts or not, that is the primary role of the insolvency professionals, either IRP or RP. Then we had columns for GST printed in them. It says that Messrs. DB Corporation action invoking Section 9 of the bankruptcy law is a clear abuse of the process of the law. That's right. Lot of amount is penalized. Operational creditor, corporate data, resolution professional. They have created nearly 200 invoices. Today, currently, they have printed and they have mentioned the GST column. 2010, there is no GST. Why they have printed the GST column? So that's why the Messrs. DB Group action invoking Section 9 of the bankruptcy law was a clear and abuse the law of the process law, and elaborated why this was so. First and foremost, DB Corporation claim was time barred also. Because they may not aware, they have created printing the invoice and prepare the invoice and all invoice are similar nature. 2010 also GST column was introduced. 2010 onwards they have created means after 3 years that that is a time bar as per Indian Limitation Act under section 18, 19, if acknowledgement of debt is there, then only that is valid. Otherwise, it is not valid. The first and most of the DB group corporate claims time barred, but out of 210 invoices filed by them, 3 years window filing such a claim. Patently, the DB Corporation has already presented as allotee of the apartment under the barter agreement and was now positioning of the operation. Although the creation was confused and shameless. Today, some of the corporates, they are doing this type of malpractice. Even though RERA is there, even though they are getting the installment from the bankers and they are constructing the house and the amount of the recurring expenditure or whatever the expenditure is there contributed by the home loan buyers, simply the builders are nothing but contractors. The home loan buyers are pooling the amount. With that pooling amount only they have to construct and hand over. But whatever the amount they are giving, they are misappropriated, diverted to others, and they are giving a wrong this one to the home loan buyers. Although the creation was confused and shameless, adjudicating authority was happy to allow without the close scrutiny or of an NCLT order notes that the adjudicating authority failed to notice of these terms. NCLT, why they have admitted? Why they have not verified? Once a dispute is there, they have to clear. Once again, the adjudicating authority verifies. Why the other person is telling that it is a disputed one? failed to notice of these facts. The adjudicating authority, that is the NCLT, failed to notice all these facts. Messrs. DB Group unsuccessfully attempted to appear in court or to file an action, MP Rera as well as the home loan buyer. Messrs. DB unsuccessfully attempted to appear for the court to file an action and Madhya Pradesh Rera as well as the home loan buyer. Whatever they have, all are wrong. The NCLT order 9 December upheld their stand. It says, we thus satisfied the entire initiation of the proceedings under section 9 by the operational creditor contrary to the scheme of the IBC. And no payment of money was due to AB Corporation, and the adjudicating authority committed error in admitting the claims of the. So the presentation of the case is also very, very important. Whenever the case is presented, it should be presented in a proper manner. Today, some of the NCLTs, on account of workload or all these things, they are unable to verify some of the cases. Very few cases are like this. Thereby, the sufferers are the home loan buyers. The sufferers are the home loan buyers. This broad narration has little room to explain money dishonest dealings that were exposed and settled under the proceedings of multiple courts. So that's why my request to all the IPs or IRPs, verify the claims, verify the application form, verify your order. Transactional order should be a qualitative one, and go through the nuts and bolts of that particular case. Then only we will get some insights of that particular case. Thereby, all stakeholders will be happy. Otherwise, during the time, paucity of time, or the time is there, during that time, if a home loan buyers not getting the correct judgment, then some of the home loan buyers, they may commit suicides also. That is happening in certain cases. For instance, NCLT order has only the mild criticism about the adjudicating authority. They have not given harsh words. They fail to verify the claim. Once the case is admitted, whether it is a financial creditor or operational creditor, whenever they are admitting the claim, simply they should not. And
Sir,
make no mention. Hello?
Sir, can I intervene?
It is over, sir. It is once the case is over, then we will discuss, sir. Right? Is it okay, sir?
Yes, sir.
No mention the shoddy actions of the resolution profession against the penalty imposed by the Delhi High Court and contempt of the proceedings of the committee. The RERA imposed a penalty of 3 crores on RP and another 3 crores on AG 8 ventures on various violations. Both parties are contested penalty before the MP High Court. So the battle continues, but there is a shine of a victory for the home loan buyers in sight. So that's why, whatever the key learnings I told earlier, read the complete application form submitted by the financial creditor or operational creditor or corporate debtor filed an application. With the resolution after allotting the case or getting the orders, and read the NCLT order completely before starting the process, and verify the claims thoroughly before admitting the claims. Fraudulent claims, further investigation is very much required. Appoint the transaction auditor who had good knowledge in forensic audit, particularly the PUF transactions of the corporate data is also required. and various agreements that are reached by the corporate data, which are pending at the time of CARP to be studied by RP thoroughly, and legal suits filed against the corporate data, and decree copies of the judgment of various courts are studied thoroughly, then follow the code of conduct regulations by RP and issued by IBPA from time to time, and follow the Limitation Act for various security documents executed by the corporate data during the course of a business or pending at the time of this one. Okay, sir. Now the case is over, sir. Now you please raise your observation, sir.
Sir, my concern is there are three parties. If you
Sir.
really see what is coming out of your presentation. First of all, thank you very much for the presentation. I think I must first start that.
Sir.
The insight was great.
Sir.
So coming back to my question, there are three parties: DB Corporation, the RP, and to my mind, to a great extent, the adjudicating authority.
Correct, sir.
DB Corporation, you have mentioned, is a listed entity. I'm surprised there are no actions or recommendations that your presentation shows has gone against DB Corporation. No, they have an audit committee, they have independent directors if they are a listed company, and yet they do this action, and the appellate authority has not commenced, nor the High Court, as I see from your presentation. So I'm limiting my
Sir,
knowledge to
that
the
is a missing,
presentation.
sir. That is a missing because once it is only a synopsis, sir.
Let me complete, sir, my comment.
Hmm.
The only thing that I see from your presentation is that RP probably overlooked, which I do not see as an overlook, but let us see it at the face value, was that he overlooked that there is a column for GST, when in 2010 the GST should not have been in there.
Correct.
For that overlooking, if you are telling me that the High Court and the appellate authority has passed penalty provisions and strictures against RP, I see a little bias, sir, against RP.
Mm.
This is my comment.
Mm-hmm.
If you are saying adjudicating authority could not see it, I can understand. RP comes into being only after the admission of the proceedings.
Mm.
And if he overlooks this side, he is being penalized, whereas a listed entity, the corporate debtor and adjudicating authority get kind of exit.
Correct.
Isn't it an unbalanced order?
Mm.
That's all I wanted to check from you.
Correct. But I have given the case in a synopsis manner, sir, and a detailed, it runs into pages. So that's why I have taken only the synopsis. And here, particularly some of the real estate people, they are colluded with other people and they are creating some fabricated documents. And as an IRP or RP, we have to go through the whatever the claims admitted before admission. We have to go through once or twice and verify with the available records of the system. And then only we have to admit. Otherwise, we are also getting trouble on account of this type of situations, sir. But this is runs into pages, sir. That is Supreme Court edition. But I have given only overview of that particular. Now, sir, here it is not a case, but opportunities are also available. The new opportunity is compliance reports. Whenever the transactional auditors are finalizing the report before submitting to COC or adjudicating authority, they will send that report to the suspended directors and they are asking the comments or complaints on that particular comments. And some of the RPs, they are providing this type of services also. And if this type of services are there, actually we should, whatever the facts are there, that the facts are to be elaborated, because suspended directors, they may not have the knowledge of what type of transactions were happened, and how to answer that, how to comply that particular questions raised by the transactional auditor. All these things, he is in dark. That's why this is also one opportunity indirectly, not directly, indirectly, it is available to the RPs also. RPs. This is only my suggestion, personal suggestion. That's all, nothing else. Sir, any other person, sir? Any others? No. Okay, sir. Now we will discuss about judicial pronouncement 2. Judicial pronouncement 2. This is ICICI Bank versus BKM Industries Limited and others. This is a 6th November 2023. NCL 18 New Delhi bench. New Delhi bench. This is a BKM industry. Key learnings. Distribution of proceeds of under insolvency resolution plans not exceeding the admitted claims. That is on the insolvency commencement date. Whatever the claims admitted are circulated to all the people. The claims admitted is mentioned in the information memoranda, and while distributing or while preparing the resolution plans also, they have to stick on to that particular amount. They have to stick on to that particular amount. But in some cases, what is happening means some of the RPs, they are closely moved with some of the financial criteria. Only a few cases. I am not talking all the people are not. So this type of things are also happening. And the first charge on the corporate data assets. Sir, while giving the loan by the financial creditors, first, once they given the loan, they will take the collateral security. If the collateral security is a big amount, suppose the collateral security value is 300 crores, but the bank is giving 100 crores. But leftover amount of 200 crores are there. But a document is only one. So some of the corporate data, so they will request the financial creditor, sir, if you give the second charge, we will take another loan from other bank, and we will offer a second charge to them. First charge is what's like that. This is also keep it in mind whenever the claims are received, whether it is a first charge, second charge, or third charge, whatever the leftover amount. But once the first charge holder, whatever the dues to be paid by them, once it is appropriated, the balance will carry forward to the second charge. That is a simple principle. Dissenting financial creditors. That is very important. Some of the financial creditors, they don't want to participate in the CAR. And suppose State Bank of India is there. They have given loan. And a corporate debtor has given 200 crores. And 100 crores, they have given loan. Adequate security is there. Why should I participate? Why should I depute my people to the CARP process? All these things. They will submit their claim, but they will tell, I'm the dissenting financial creditor. So once the CARP is over, the banker is eligible to sell the asset. Once they sell the asset, then whatever dues are there up to that point of time, they will recover, not from up to the date of admission of the claims. They will recover. Once they recover, whatever the balance is there, the balance they will pay to the liquidator in case of liquidation or other, particularly the RP or IRP is there, they will give that amount to them. Distribution amongst creditors within the purview of COC is a commercial wisdom. So in most of the cases, COC commercial wisdom, we are using the word COC commercial wisdom. When submitting the resolution plans, we are preparing the evaluation matrix and we are giving the ranks and the first rank, second rank, third rank. It doesn't mean that the first rank of resolution applicant will get the win the bid, and even third or fourth, whatever they wish, particularly the COC wish, they will finalize that resolution plan. Even adjudicating authority, they don't have the powers to enter into the commercial wisdom of the COC. Now, the BKM industries. A small case study that is also latest. And what is happened in this case also we will discuss. The company is primarily engaged in the business of the metal packaging product, particularly aluminum, semi-rigid containers, shipbuilding, naval design services, and agro commodities. They are the pioneers in this area. Its segments including packaging product, mosquito coil, metal products, and engineering others. That is the BKM products. The recent, particularly the recent edition, particularly NCLAT company, appellate tribunal, Delhi bench, in the matter of ICICI Bank versus BKM Industries, has a significant implication for the distribution of process of the insolvency resolution plans. So, insolvency resolution plans, whenever they are finalizing, they have to take into account of the dissenting financial creditors also. They are eligible for full amount, not the amount as on date of the insolvency commencement date. But if at all, I am also one of the party, particularly financial creditor in the COC, then I am eligible whatever the amount admitted by the RP, IRP at the time of insolvency commencement date. So the recent edition of the by the NCLT Delhi bench in the matter of ICICI Bank versus BKM Industries Limited has a significant implication for the distribution process of the insolvency resolution plans. The NCLAT dismissed an appeal clarifying the distribution of the secured creditor must align with the admitted claim rather than dictated by the security interest over the assets of the corporate debtor. The dissenting financial creditor is telling, I am eligible for full loan outstandings. But NCLAT told, you are eligible up to admitted claims. You are eligible admitted claims as on insolvency commencement date. Then clash has arisen. One side the banker is telling something, the NCLAT view is different. The corporate insolvency resolution process against BKM Industry was initiated on 30/12/2020 on the section of the insolvency and bankruptcy by Trimurti Associates Private Limited. The appellant ICICI Bank submitted claim 1552 crores, which was admitted by the resolution, making ICICI Bank a member of the Committee of Creditors. On that particular insolvency commencement date, the ICICI Bank amount is claim is 1552, and they invited to participate in the COC committee, and that was informed by the resolution profession. The resolution plan presented by Unique Global Paper. Actually, the BKM Industry, the bidder is, particularly the prospective resolution applicant is Unique Global Paper Limited, proposing distribution of payments towards the secured creditors based on the proportion of their admitted claims. Resolution plan presented to Uni Global Papers Private Limited, proposing distribution of payments towards the secured creditors based on proportionate of their admitted claims. Then, however, dispute arises. On 14th and 15th COC meeting regarding a methodology of the distribution, particularly whether it is a liquidation or a resolution plan, the distribution should be some scientific approach, particularly based on the regulations or code, whatever the whether it should be according to the outstanding debt or security interest. That is the vital point of this case. Whether outstanding or security interest. The key issues revolved around the applicant's claim for distribution based on the security interest, contending that he is the first charge holder of the corporate debtors. Normally, the bankers, once they have taken first charge, the full amount to be recovered if they are not participating in the CARP process. Once the CARP not process dissenting, then they are eligible for full amount. If at all they are participated, whatever the claims admitted on the date of admission of the insolvency commencement date, that is final. That is a freeze. That is a freeze. Later on, no sir, the CARP run into 2 or 3 years. Now, as on date, the accrued interest is this much. This is also, please admit, miss, no. Once he is participating in CARP, whatever the admitted claims are there, that is final. Additionally, the appellant is a dissenting financial creditor, argued for entitlement of the liquidation value under section 32B of the IBC, challenging that COC's commercial wisdom. The dissenting creditor is arguing, no, I am not agreed with the commercial decision of the COC. In most of the cases, commercial wisdom, COC decision is final. But with regard to this one, ICICI Bank told, no, I am not agreed for this commercial wisdom of the COC. I am entitled for the liquidation value, not the insolvency commencement date value. Because I am a dissenting the financial creditors. I am eligible for under section 32B of the IBC. Then the necklight in its verdict emphasizes the importance of COC decision. It is highlighted that a specific agenda item of distribution measure duly considered by the COC. Whatever the COC decisions are there, that is final with regard to this one. That the commercial wisdom, ultimate authority, resulting approval based on the proportionate of admitted claims of the security creditors. All security creditors, proportionate to the admitted claims, the resolution plans will be finalized. The NCLAT told like that. They have given its verdict also. The NCLAT referred to relevant Supreme Court judgment, including Messrs. India Resurgence ERC Private Limited, Mr. JP Kensington Bluewood Apartments Welfare Association, NBCC, a firm of a legal standing of a COC edition. All these things they mentioned in that particular verdict also. The NCLT concluded that the dissenting creditors are entitled to the concluded that dissenting creditor, financial creditors are entitled to the liquidation value of the debt. However, it reiterated that the distribution among the creditor within the purview of COC's commercial wisdom. The tribunal dismissed the appeal, emphasizing the importance of adverse adherence of the COC approved distribution. importance of adherence of the COC approved. Then in the site of the NCLT decision, it is evident that the distribution of security creditors must align with the admitted claims, and the dissenting financial creditor retain the right to the liquidation value of the particular debt. The ruling underscores the significance of a COC decision in the insolvency proceedings and affirms that principles of commercial wisdom in distribution matter lies with the domain of COC. In most of the cases, we are talking about COC decisions, particularly finalization of the resolution plans is their domain, the new opportunity. So here, what I told is, even though there is a commercial wisdom in finalizing the resolution plan, but once the dissenting creditors are there, particular financial creditors are there, they are eligible under section 30 subsection 2 clause B of the IBC code, particularly the liquidation value in this case. Particularly today, the banks, some of the banks, private sector banks, like a Federal Bank, Bank of Karnataka, all these things, they are not aware of the code, and they are also requesting IPC to participate on behalf of the financial creditors in the COC meeting. That is also one opportunity. Being a banker, I know all these things, and that's why I'm disseminating this information to you. Sir, any discussions, sir? Sir,
Maybe afterwards, after that, in that, sir.
sir, shall we break for tea now?
Yes, we can.
Okay, sir.
Yes, thank you.
Okay, sir. Only 10 minutes break for tea. After that, we will discuss some more cases. So shall I start now, sir?
Yes, sir, please start.
Okay. So the third judicial pronouncement, that is, this is also a latest case, particularly on MSME. Everybody knows about MSME is an important sector in the economy. They are giving a large employment opportunities to the people in the country. They are contributed a lot in gross domestic product, and they are also contributed a lot for foreign exchange reserves of the country by way of exporting their goods. That's why the government of India, the Reserve Bank of India, all are giving a lot of importance to the MSME sector by providing interest concession or margins whenever they are taking loan, the less margin for MSME, and not only that one, restructuring of loans and the collateral securities offered by the bank, that is also collateral security less when compared to other than MSME corporates. Based on this judicial pronouncement, if you go through the Supreme Court order, only 12 pages they are highlighted about the MSME one, and how the MSME is giving a lot of importance by the government of India. So based on this only, that is, this is also a recent case. The case is based on MSME. Hari Babu Tota versus Sri Aishwarya Infra Limited. The key learnings are MSME segment, a lot of importance given by the central government. While in CIRP process also, we have to pay some special attention while handling the MSME corporates. And the section 29A and 240A specially is designed to include in the code to protect the MSME sector of the country. Whatever the sections are there, these people are not eligible to submit the resolution plan except MSME that is mentioned in 29A, and 2240 they are eligible to submit the resolution plans also. And the PPIRP, pre-packed insolvency production, this is an additional product designed by the Insolvency and Bankruptcy Board of India to protect the MSME sector. Why? Because it is a small baby, and big corporates, CIRP is suitable. For small babies, the PPIRP is also very much suitable, because CIRP is also a costly one. That's why they have given special attention, and they have formulated one more product. The various products are there: IBBA, the CIRP, the liquidation, the personal guarantor to corporate data, or the PPIRP. All these are various products designed by the particularly the Insolvency and Bankruptcy Board of India under the Insolvency Bankruptcy Code 2016. So that's why the PPIRP is also specially designed to protect the MSME sector. And the Government of India introduced the pre-packed insolvency for MSME under IBC by promulgating the Bankruptcy Code Amendment Ordinance on 2021. The ordinance also provide cost-effective and concessional resolution mechanism for the promoters of MSME for the resolution plan with a minimum default of 10 lakhs under a PPIRP. So others 10 lakhs as 1 crore. But here default 10 lakhs is also there comes under the purview of the PPIRP. Due to pandemic COVID, many MSME corporates which were solvent before onset of the COVID-19 have suffered financial distress, which pushed into the insolvency. That's why Government of India is giving a lot of importance. Some MSMEs were already facing financial distress before the onset of COVID-19 and push into deeper stress in COVID-19 also due to COVID-19. So this case study, this type of case study, nearly 10 case studies are different variants, different issues. But if you see the judgments, all the judgment copies also, they highlighted the importance of the MSME. We have to protect the MSME. We have to give the importance under IBC code also, like that the various judicial pronouncements have released. And everybody knows about this one. Under MSME Act 2006, that is 2020, they have issued the MSME micro below 1 crore, plant and machinery, turnover not exceeding 5 crores, small 10 crores below, and 50 crores turnover, and medium enterprises 50 crores and 250 crores. So before any the case are going to take up by you, if at all it is an MSME, whether these turnover and plant and machinery in the balance sheet, it is there or not. If at all it is crossed, they are not eligible. Once crossed from that date, they are not treated as a MSME. So for this, everybody requires the Udayam MSME registration portal. That is important. All enterprises registered an MSME to June 30th, 2020 were reclassified as per the limits mentioned above for making the application for PPRP. A MSME must register with the Udayam MSME registration portal and the government MSME registration agencies, etc. So here, how in this case, particularly they focused, the Supreme Court is also focused on the Sri Akshaya Aishwarya Infra Company, that is a Haribabu, etc., etc. And not only that one, from time to time, every year, the Reserve Bank of India also giving issues guidelines to the banks for restructuring of the loans of MSME sector. Now coming to the case, Haribabu Tota versus Sri Aishwarya Infra Company Limited, November 29, 2023. Even if MSME registration obtained post commencement of CIRP, the promoter is eligible to submit the resolution. In most of the cases, if they have not submitted the Udayam certificate, that MSME portal certificate, some of the resolution professionals, they are rejecting the resolution plans submitted by the promoters of that is erstwhile the directors of the company. They are rejecting. That's why this type of cases, more than 10 is there. To my knowledge, 10 is minimum. To my knowledge, minimum 10 cases are there. Recently, 2 cases are awarded by Supreme Court in other issues also. Even if MSME registration obtained post commencement of CIRP, the promoter is eligible to submit the resolution plan by taking exemption from under section 240A, IBC, etc. So once at the time of CIRP, if MSME certificate is not there, we should not decline the proposal. Thereby we have to face the consequences. In this also, Haribabu Tota and Shri, the company also, Supreme Court penalized the resolution profession, not admitting the MSME resolution plan by the RP. The Supreme Court has held that promoter of a corporate debtor is eligible to submit the resolution in terms of 240A of the insolvency and bankruptcy code, even if the corporate debtor is registered as micro small enter after commencement of the CIRP also. after commencement of the CAR. So, in this case, the resolution professional is declined that particular proposal. The division bench of the Supreme Court set aside the orders of the NCLAT, wherein the promoter of MSME corporate data was declared ineligible to submit the plan on the premise that the MSME certificate was obtained post commencement of CAR. They have rejected, but they are eligible. The Supreme Court given the verdict. In that verdict, it is 28 pages. Out of 28 pages, Supreme Court of India given the importance of MSME in the country. That's why I given some brief introduction about the MSME. Even in the judgment also, nearly 10 pages they are focusing on MSME. The both parliaments, they have they enacted, they have given that particular introduction of that particular the 240A, and they are giving special attention, particularly MSME. The both parliaments, Lok Sabha, Rajya Sabha also, and this IBC, under IBC also, the new product is devised, developed, that is PPIRP, pre-packed insolvency resolution. It is particularly for the MSME sector. Facts of the case. On 6/4/2021, Sri Aishwarya Infra Company Limited corporate data was admitted into CARP. The date is 6 April 2021 by the National Company Law. Subsequently, the corporate data registered as a micro small enterprises on 15 after 3 months of the date of admission of the particular CARP, he registered with MSM. Mr. Haribabu Tota, he is a resolution profession of the corporate data. He was appointed for that Haribabu Tota. The resolution professional presented the plan before the National Company Law Tribunal, Bangalore, as propounded by the promoters, approved by the Committee of Creditors, but in terms of order 28/2/20, the application was dismissed on the ground that the promoter could not have presented the plan as per the section 29A of the IBC, which puts a bar on certain persons from becoming the resolution. Based on that 29A, they have rejected. Issue is whether the corporate data not having MSME status at the time of commencement of CARP would disqualify the resolution application under section 29A of IBC as a benefit under 240A would not be available. That is the issue. That is the issue. So on this issue only, the case was filed with the Supreme Court. Supreme Court is given the verdict. The court examined the section 29A, which listed down the persons ineligible to submit the resolution plan for corporate data, including promoters and a related party of the corporate data, and section 240A also provides that the bar under section 29A to submit the plan would not apply CARP of MSME corporate data. MSME corporate data, they are eligible, even though they are defaulted with the bank on account of a various reason. But that account is classified as a MSME segment, then that type of the sector given special permission by the government of India, and the 240 also specially designed for them only. Consequently, the promoters of MSME corporate is eligible to submit the resolution plan for the same by availing the benefit exception under the 240A of the IBC. The court opined that the case at hand, there is no bank dues outstanding which would all invite the concept of NPA much lesser than 1 year. Further, only preferential transaction was identified by the resolution professional, but NCLT has not passed any order in that regard. And lastly, 29AH, no factual application given in this scenario. So that's why he is eligible, even though at the time of commencement of the insolvency commencement date, even though he is not having the MSME certificate, after that, if at all he is registered, he is eligible. It was concluded in terms of section 29, the promoter of the corporate was not disqualified as per se, dissented him from the presenting the plan. The court took with the exemption of MSME application, section 29A has been done due to nature of a business carried out by such entities. The court has set aside the NCLT orders and held that even MSME registration obtained post commencement of the CIRP, the promoter of such a corporate debtor would be eligible to submit the resolution plan in terms of 240A of IBC. So the Supreme Court has given judgment in this regard. There is one more judgment also given. So even though post the insolvency commencement date, if at all registered, it is deemed to be treated as that the unit is eligible on the date of commencement of the CIRP. So that type of additions are there. Second one, some of the units, the earlier it is not an MSME, but on account of revised guidelines that is happened in 2020, some of the units are not registered with the Udayam portal of Government of India. Now, if they are not registered and the limits are within the purview of that particular guidelines issued by the Government of India, they are eligible and they have to be treated as a MSME only. Not only that one, if the bankers are classified that account as an MSME, that is also to be treated as a MSME. For that also, they can produce the bank's sanction letters also to the adjudicating authority while submitting the resolution plan. If at all they have forgotten to submit, to register that unit under MSME portal. So MSME portal registration in certain cases, if at all they forgotten, then after that we should not simply rejected that resolution plan. That benefit is exclusively given for MSME sector. That's why once or twice before rejecting the resolution plans submitted by the MSME resolution and the MSME promoters, verify once or twice and admit that one. Analysis. This judgment is a welcome step as it upholds the intent behind the inclusion of section 248. That's why I told about government is giving priority. Both the parliaments, they enacted that particular section also included in this one. And rather than defeating the purpose of the section by getting into the technicalities, no, before, after, all these things, a directive, it is directions given, but if at all they have any small aberrations are there, that is to be separated. And as an IRP, we have to admit the MSME cases subject to whatever the 29A conditions are there, all conditions are to be, if at all not fulfilled, those conditions are there in that particular, not eligible conditions are there in the particular the resolution applicant, that promoter of that MSME, we can decline, but only for that account, if at all NPA, on account of various grounds, that resolution plans are to be admitted. Though the judgment considered overall scheme of things, The judiciary shall maintain balanced approach, and the ambit of Section 240 shall not be widened to the extent of dilutes the purpose of 29A of IBC 2006. So that's why this case, number of cases are there. Because I have gone through the number of cases under Section 29A and 240 also. Some of the RPs, because on account of their communication gap and other things, they have rejected the proposals, and the suspended directors, promoters, they are approaching to the adjudicating authorities, and adjudicating authority in most of the cases, they are favoring to the MSME sector. So that's why this is a key learning point in this regard. Hence, MSA segment is a lot of importance given by the central government. On the flimsy grounds, we should not decline. Section 29A and 240 is specially designed to include the code to protect the MSME sector of the country. PPIRP, additional product released by the IBBA to protect the MSME sector. Not only that one, the new opportunities, particularly PPIRP is not developed. Pre-packed insolvency cases are very few cases are there across the country. Actually, PPIRP is to be originated by only by the corporate creditor, not by the financial creditor, not by the operational creditor or others. Only this is to be initiated by only the corporate creditor. But most of the MSME units across the country, they are not aware of this particular clause. That's why they are doing that. They are rejected. Most of the people they are not aware of corporate data are not aware of this one. That's why number of cases are not filed with the various NCLTs. But here, my suggestion only. This is only opportunity is also available. Suggestion only. What is that suggestion means? Dissemination of information to the MSME corporates through cluster meetings. Even take, for example, I am in Hyderabad. In Hyderabad also, nearly 10 locations, MSME clusters are there. Clusters means 150 to 200 MSME industries are located at one point, like Balanagar or Katedon or different places that MSME cluster. In the MSME clusters, every month they are used to conduct particularly the meetings, their problems, particularly on GST or power shortage problem or various problems or the pollution control issues, etc., etc. All promoters are assembled at that particular meeting. During that meeting, if at all any IPs are interested in this area to handle the PPIRP cases, then if they disseminate that information in that particular meeting for half an hour or so, this provision is also there. If at all you want to avail on account of a liquidity problem, on account of a turn your account in a special mentioned account 0 or 1 or 2, then you please come to my this one. Then we will provide service and the base resolution plan we will prepare and we will discuss. So one beauty is there in pre-packed insolvency. So before admitting or after admission. Before admission, that is not defined in IBC. After admission only, the process is defined. Before admission, the RP and the MSME promoter, they have to prepare the base resolution plan. This base resolution plan, they have to submit it to the bankers, and the bankers, once they agreed, then they will give the letter. With that letter, whatever the process are there, the process to be completed and submit the application to the NCLT. Then only they will admit. So here, the problem lies in PPIRP is the publicity, the communication gap is there. Normally, The bankers, if at all they have financed, they don't tell about the P2ARP to their clients. So that's why this information to be percolated to the ultimate end user, that is MSME promoters. That too in every state, every tier 1, 2, 3 centers, MSME clusters are there. MSME clusters every month they will use it to conduct the meeting. In that particular meeting, if that information passed on, a brief introduction of the pre-paid insolvency, how you are going to support to that particular MSME, then it will increase the fee-based income. This is my personal opinion and suggestion. Is it okay, sir? Any doubts are there, sir, in this regard? Sir, madam. Sir. Sir, any doubts and clarifications? Any discussion points? Sir. Is it audible, sir? My voice is audible?
Yes, sir, you are audible.
Sure. Yes, sir. Okay, sir. Now, the third judicial pronouncement. The fourth one is judicial pronouncement on. Today, what is happening means change management in most of the companies are happening. The company, X company, the management is changed and further changes are happening. In this process, particularly some of the credits they avail from either operational creditor or the financial creditor. They are rejected the same, the current management is rejected the claims. Change management is, if at all it is happened, they have to pay the amount to the creditors. They should not disallow or they should not they should not tell that I am not responsible for that amount like that. Based on that only, this judgment was given. It is none of the business, particularly change management happen means whatever the earlier dates are there, that is the responsibility of the current management. So on that particular aspect only, the same was developed. Shaw Paper Mills Limited versus Sri Rama Newsprint Papers Limited, NCLT Ahmedabad bench, 18th October 2020.
I'm waking up late, but can I go
Tell me,
back to
sir.
the
Tell me, sir. Tell me, sir.
second, okay. Two things, sir. So in the second, now if I can summarize it for my understanding, the dissenting financial creditor will be given the distribution of the proceeds to the dissenting financial creditor will be in accordance with his admitted claim and not on his security interest, but it will still be governed by section 53, sir. Am I right or wrong?
Sir, here, particularly the dissenting creditors, whoever is not interested.
And because I have ICICI only in one case as dissenting financial creditor, so I wish to be sure that I do the right thing.
But here, sir, always they are eligible for liquidation value.
Correct.
Not the insolvency commencement date value. Why? Because their security is adequate. And second one is they are not participating in that particular process. Definitely, they are eligible for liquidation value, not the insolvency commencement date value. But what is your opinion, sir?
Which is what section 53 says, no, sir?
Yes.
So they will still be entitled to the liquidation value. So what was the issue? Here the issue was not on liquidation value, but on the security interest they wanted.
Security interest means, sir, liquidation value means.
What was the issue here, sir? Then
Issue, sir. Actually, resolution plans are finalized, sir. In the resolution plans also, the resolution applicants has to pay some amount to the financial creditors or operational creditors. They will give some plan. I will pay this amount, this much amount to this person, this much amount to this person, like that.
correct.
But in that particular resolution plan, the COC is admitted based on the admitted claims only, proportionate of admitted claims only, not based on the security value of that particular dissenting financial creditors.
Okay.
That's
So,
why.
but the security value has no.
This dissenting the financial creditor is not interested for that resolution plan. He is not interested. Why should I take that particular proportionate amount based on that particular admitted claims? I am a dissenting financial creditor. That too, I am eligible for liquidation value. Why should I take less amount?
Yes, he gets higher amount. I agree with you there. So what you are saying is,
Sir.
Basically what you are saying is,
sir,
the governing principle is still section 53. The security interest or admitted claim has no relevance for the purpose of distribution of proceeds to the dissenting FCs.
Correct.
Thank you, sir.
Sir, with
in one such case, in another case, as far as your third judicial pronouncement is concerned, so before this judgment came, one of my CDs, which was to be bought as a going concern under section 35, was rejected by both NCLT and NCLAT before this judgment came for the absence of the MSME certificate.
But this is a recent judgment, sir.
This is a recent judgment.
Yes, sir.
So, can we revive the earlier proposal?
Sir, what was happened to that the process? It is in still it is live or closed?
The liquidation of the CD is still live, but that
Sorry,
bit obviously because also, there is a NCLAT order still rejected.
Correct, sir. Correct. Even if at all it is in the liquidation process, still the MSME promoters are eligible to compete with us.
Correct.
It is not only CIRP, it is not only under CIRP, but also under liquidation. But
it means they will have to go back to the NCLT again because now there is an order of NCLAT and NCLT against them. So I cannot revive it unless I go back to the...
Correct. If at all it is the liquidation process is going on, then the adjudicating authority take their view. They may take their view in a different manner because we are unable to predict what decision they are going to give.
But so we need to approach them again in view of this order.
Yes.
Okay.
I am not aware. Earlier I am not aware. I am the suspended director or promoter of the company. Earlier they have rejected. Now I am not aware. Recently I got the information that the Supreme Court given special, whatever the benefits the MSME is there, they restored that one. So based on this case, again, I can file if the liquidation is on, not off. If at all CIRP is on, based on this judgment, I can appear. I can file a case. That is possible, sir. That is possible. But the case should not be closed.
Okay, sir. Thank you.
Once the appropriation of payments are there, waterfall, as per waterfall mechanism, if at all payments are made, then there is no use. There is no use. And
Understand, sir.
if at all CIRP is also completed and the company handed over to the resolution applicant, there is no use. If at all they are in live, either in CIRP or liquidation, based on this judicial pronouncement, they can approach the higher courts, particularly the NCLAT or Supreme Court.
Okay, sir. Thank you.
Okay, sir. So that fourth case, Shaw Paper Mill Limited versus Sri Rama Newsprint Paper Limited, Ahmedabad, 18th October 2020. Key learnings. Pre-existing disputes are to be verified thoroughly. Whatever the claims are admitted, whatever the litigations are there in the company, as an IRB or RP, I have to go through once again. And what is that pre-existing dispute? Why it has happened? What is the conclusion? All these things I should aware. Otherwise, simply rejected any case, then it will create a problem later on. Change management is an internal matter. Sir, in one company, the board is changed. The financial creditor or operational creditor, that is he need not aware and he need not give any permission to them for the change management, all these things. But if at all any change management is there, particularly the financial creditor, whenever he is giving any finance or loan to the particular company, any change management in the board or any stakeholder shares, all these things brought to the notice of the bank. If at all it is not brought to the notice of the financial creditor, then it is not valid. So that's why, particularly the operational creditor who are giving that supply of services, the providing services or supply of raw material to the company, the change management is an internal matter of the corporate data, in which operational creditor has no role to play, but in financial creditor, it is the role. Unless until informs to the bank, you should not change the board till the currency of my loan. That's why the terms and conditions or arrangement letter, whenever the loan is sanctioned by the financial creditor to the companies, they will specifically mention. But for an operational creditor, simply they are supplying the stocks. The operational creditor has no role to play. Change management of the corporate cannot be ground for extinguishing or wiping of the past liabilities. If at all change manager is there, whatever the earlier management issues, if at all you are set off from this, that is not past liability. They owed to the operational credit. No, this is a new management. Whatever the earlier management borrowed, all these things we should not pay like that. They should not talk. So based on this points only, Shaw Paper Mill Limited and Sridham Newspaper Limited, NCLT Ahmedabad case, the decision was given. This is the key learning points. The petitioner filed operational creditor as dismissed by the NCLT on the contention. of existing dispute raised by the corporate. Whenever the operational criteria has filed an application, definitely corporate data will tell, no, sir, that is a disputed one, sir, for the last 2 years. That's why I have not paid. Being a NCLT, why dispute? Why the operational criteria is telling that it is not a dispute? Why the corporate data is telling that it is a dispute? You should go into that details. If it was simply not listening and given the verdict, then it will create a problem. That was happened in this case. The same was happened in this case. The NCLT revised the order passed by NCLT and allowed the petition since the corporate data was trying to take advantage for non-payment of the debt. Corporate data always will tell, sir, that is a dispute, sir. Because of that clause is there in our particularly that the IBC code. If at all dispute is there, the adjudicating authority is not the dispute resolution form. That is a separate. You go to different courts for disputes. This is only the resolution plan mechanism or recovery plan mechanism we will discuss. In most of the cases, they did like that. Take the advantage for non-payment of the data once admitted under the shelter provision of the section 9. Always a corporate data, they will tell and they are not going to pay amount to the operational creditor. Once operational creditor told, sir, this is my amount, I have supplied the stocks or services, whatever it is there, go into details by the adjudicating authority. In this case, that is missing. The present was an appeal filed as an appellant against the order, impugned order, passed by the adjudicating authority National Company Law Tribunal, Ahmedabad Division Bench Court 1. Definitely, if at all it is not a dispute, if at all I am the operational creditor, definitely I will approach the higher courts. By impugned order, the adjudicating authority dismissed the CARP application filed by the section 9 of the IBC. Today, earlier, the number of cases are not more. Today, the cases are increasing day by day, day by day. Then, whatever the gaps are there in the regulation or code or knowledge gaps, all are set right over a period of time. Take, for example, personal guarantor to corporate debtors, Supreme Court judgment. Supreme Court given no question of process of natural justice applied to this case. You have given guarantee for the corporate loan, you have to pay from your pocket. That is the firm from your personal property. Then the Union Bank of India, they hold nearly 2,000 cases on account of the stay orders of the Supreme Court. Last month, Supreme Court has given the judgment. Now they are going to file all the personal guarantor to corporate data in various NCLTs across the country. 2,000. If at all it is a stay in Supreme Court, what is the purpose of filing the case? Now the Supreme Court released that one in one go, nearly 351 or 400 cases. One go, the Supreme Court judgment, the Supreme Court, the Chief Justice of India, Honorable Chief Justice of India, given the judgment and 350 to 400 cases in one go, given the judgment. So here, whenever dispute is there, once or twice, By implied order, the adjudicating authority dismissed the CARP application filed under Section 9 of the IBC by the operational creditor for initiation of CARP resolution against the corporate creditor. Dismiss decision. NCLAT have duly considered the arguments submitted advanced by the learned counsel of the both parties. Whatever the arguments they are giving, listen and give the judgment accordingly. And peruse the records carefully. This is the wordings of NCLAT, not me. The issue in the present case is the NCLAT consider is whether operational data are above the threshold limit. What is the threshold limit? 1 crore and above. That is satisfied. 1 crore above dues is below 1 crore means definitely it is not comes under the NCLT. The minimum default is 1 crore and above. Earlier it is 1 lakh and after pandemic COVID it is 1 crore. Become due and payable. Second condition, due and payable. If at all it is still the time is set for payment, immediately the financial creditor or operational creditor, they should not approach the NCLT. Once my installment is due and I am not paid, then only they have to approach the adjudicating authority, not before that. And due and payable to the operation, and once I defaulted, then only they have to approach the NCLT for recovery, for resolution mechanism. Thereafter arising whether the pre-existing third condition to be verified by the adjudicating third condition, whether existing dispute is there in that particular loan, whether it is an operational creditor or financial creditor. If a pre-existing dispute is there, they will not admit. If a default payment is not there, they will not admit. If the due is not happened, before that only financial creditor or operational creditor filed, it is not admitted. If the amount is below that one, they will not admit. The NCLAT once again, they revisited this 4 points. It is well settled Section 19 proceedings of IBC. The adjudicating authority is not enter into the final adjudication with regard to the existing disputes between the parties regarding the operational rate. But what was to be looked into whether the defense raised by the corporate is a nonsense defense or not. What the corporate debtor is telling, whether it is a nonsense or what, they are looking that one. What is once it is a dispute is arguments are happening. What is the dispute? You go into that particular dispute. Why the dispute is there? Any interest dispute or any disbursement dispute or any date, due date dispute? All these things are to be verified. It has been noted by the adjudicating authority that there is no prior dispute regarding the quality of goods or materials supplied. Operational creditor. There is no dispute. Okay. Dispute is not there. Very good. Then they have to admit. But what are the other conditions? What, however, been held dispute is adjudicating authority is a difference of you, the actual amount payable by the corporate debtor to any difference amount. What, however, been held the dispute by the adjudicator, difference in view of the actual amount payable. That is the dispute. Not the quality of the goods, not the price of the goods, or etc. But the real dispute is the actual amount payable by the corporate debtor to the operation. What the dispute is, the operational creditor supplied the goods to that particular company. At that time, some management is there. The management changed and a new management came. The new management are rejected the amount to be paid to that operational creator. That is not correct. The change of internal management is not related to reject the you should not reject the claim on account of change management. One reason for the difference have been cropped up on account of express unwillingness on the part of the corporate data. No, sir, I don't want to pay that amount, sir. That amount borrowed, that goods are supplied in the earlier management of the company. I am the new management. That's why I'm not paying. Then that is a dispute. That dispute is not applicable. Dispute means the quality, the price, and all these things. Change of a management is not a dispute. Unwillingness on the part of the corporate to clear up the liability outstanding data period prior to the change of the management. Poor operational creator who supplies the raw materials or poor operational creator who provides the services to the company, how he will know that once the change management is there, the liability will also be transferred to the new management. They should not tell, I am not responsible, I am not accountable for that. The other reason for the difference has been attributed by the corporate data, non-reconciliation of interest. That is your job. You reconcile. Once the accounts are not reconciled, once you are rejected that claims, that is not a dispute. First, whatever, whether he has sent the invoice, and the invoice, the goods are also, he has supplied, and a transport document is also there. The bill of exchange is also signed by the earlier management. Reconciliation is not the botherization of the operational creditor. It is not a dispute. Since the adjudicating authority came to conclusion, serious dispute between the operational creditor and the creditor, quantum of operational debt. Due to payable placing that depends relay on the corporate data to section 8, notice after perusing above reply. NCLA find that the adjudicating authority polished over the fact of the corporate not challenged the outstanding liability which had admitted on 15/4/2007. Once he has admitted one claim, particularly the change management was happened in the company. Whatever the earlier management liabilities are there, that is also admitted by the new management. In that case, they have to pay. We should not tell that earlier management had taken the stocks. I am not responsible to pay, means that is not. Furthermore, claiming that amount is due to payable to the operation essential to find that a corporate debtor made this statement with the qualification only invoice post change in the management have been paid in full. NCLT, this qualification needs to be examined. They simply, without verifying their books, I have paid. I have paid means whether you have paid through RTGS or NEFT or check or cash, taking the acknowledgement from the operational creditor. NCLT, this qualification needs to be examined to find out whether the supported claims being a pre-existing dispute. NCLT or the considered that a stand taken by the corporate debtor in their reply demand notice that they are not liable for the claims of the operational creditor prior to the change of the management is a tenable argument. That is not correct. Prior to the change management, whatever the dues are there to the operational creditor, I am not responsible means that is not correct. Change management is an internal matter within the company of the corporate debtor, which operational creditor has no role to play. change management of the corporate data cannot be a ground for extinguishing or wiping of the past liabilities that they own to the operational credit. Management from time to time, it is a continuous organization. Company is a continuous perennial organization. Some of the directors may inject, some of the directors may retire, and some of the key manager person will come, and some other. In that particular this one, whatever the earlier management dues are there, I don't pay means that is not correct. Therefore, it is not open to the corporate data to contend they are not liable for the outstanding liability which had occurred during the period of the previous management and hold is this as a dispute, ground for dispute. This is not a dispute. Dispute means quality of the goods, payment time, rate of the goods, and if at all they have not supplied within the time, so many things are there while supplying the goods. Whatever the purchase requisition given by that particular company to that particular supplier, whether he fulfilled all these things or not. In that any violations are there, that may be treated as a dispute, not this one. Therefore, it is not open for the corporate data to contend that they are not liable for the outstanding liability which has occurred during the period of a previous management and hold this as a ground for dispute. The untenability of this contention reinforced by the fact that they are already categorically acknowledged and admitted the outstanding liability in their communication date. Today they are telling change management. At the time of change management, they admitted this claim and they acknowledged it through communication also. In that case, they are liable to pay. They should not disown that particular responsibility. From the facts of the present case and the material on record, it also appears that the corporate tried to take the advantage of their own wrong of being carelessness in reconciling the accounts in spite of nearly 30 requests made by the operation to do so. 30 communication messages by way of registered post or legal notices, all these things they have not replied. If this is admitted, this is not admitted and given in favor of that particular corporate debtor, then in future, no creditors for supply of raw material or services will not be provided to any company. Today, the companies are running by the not the bank loan. Bank loan is also less amount. The creditors who are supplying the raw materials or services, etc., etc. In the entire discussion by the adjudicating authority, NCLT find that no notice has been taken in respect of repeated and multiple reminders sent by the operation in this regard. In the result, NCLT thus view that the grounds of rejection of application was erroneous. The NCLT, without verifying all these things, they simply rejected the application submitted by the operational creditor. That's why he approached the NCLT. Appeal is allowed. What is the pre-existing disputes? Particularly, if you refer the old cases also, the Supreme Court noticed the position of Mobilex Innovations, Kurusa Software Private Limited, that was taken into account the existence or otherwise the disputes or suit or arbitration proceedings prior to the receipt of demand notes. If at all it is there, then that is called pre-existing disputes. Otherwise, no. If at all any arbitration is there or any
वो तो
shoots are
मॉनिटरिंग
filed,
कमेटी करेगी ना, और दैट यू हैव टू गिव एन एनओसी कि आपको वो देना पड़ेगा, हमें ऑब्जेक्शन नहीं है सिविल को, इसकी एक प्रोसीजर है, हमने सिंटेक्स में भी किया और मैंने बहुत सारे कंपनी में किया है.
the Supreme Court reiterated the principle that separating the grain from chaff, the NCLT is not required to be satisfied. The defense is likely to be succeed. It also enough that a dispute existing between the parties. There needs the plausible contention require investigation for adjudication. In this case, the investigation is not. The correctness, truthfulness of such a dispute prior to the receipt of the demand notice is a matter of evidence. In this case also, correct dispute not find out by the NCLT. That's why NCLT verified and given the judgment accordingly. The Supreme Court took note the following facts. To conclude, there is a pre-existing dispute between the parties. Correspondence between the parties, they have to look into. Regarding the dispute pertaining to amount payable to the appellant or not, that is to be verified. The amount due to the appellant is not being reconciled, or the amount payable to the appellant is included in debt recovery statement in the BFR, particularly earlier. The Board for Industrial Financial Reconstruction said that is no more on account of the repeal of the SICA Act, Sikh Industries Companies Act, formulated in fairness. In view of the pre-existing dispute between the parties, the matter is remanded to NCLT for reconsideration of section 9 of the application. So here, that's why I told, existing disputes means, what is the existing disputes? What is the litigations? If at all any notices are received by the IRP or RP, once again go to that inside that, even NCLT, their role is like that. But as an IRP, if at all any complaints and other things are there, once again go through that one. Section 9 of IBC, application for initiation of CARP by the operational creditor. Because here, in this case, the total information is also elicited. That whatever the section 9, whatever the pre-existing disputes, all these things are after expiry of the period of 10 years, 10 days from the date of delivery of the notice. Subsection 1. If the operation does not receive the amount of the corporate or notice, under section 8, operational creditor may file an application before the adjudicator for initiation of the The application to be filed such a form manner accompanied with the fees as mentioned, that is 2,000 rupees or so. The operational creditor along with the application, these are to be enclosed. Invoice for a demand payment and the affidavit that is must. No notice given by the relating dispute of the unpaid operational creditor. That is a declaration that affidavit is must. Then only the NCLT will accept. If the operational creditor is not submitted the affidavit, they don't admit the case. Copy of the certificate from the financial institution, it is a directory, not mandatory. Even in most of the cases, letter from that particular, the borrower, particular financial creditor, letter is to be taken. If that letter, whether the amount is credited to his account or not, letter, that is impossible thing. How many years they will go from the date of supply to till date? If at all 1 year lapse, 1 year statement means that is impossible. Bankers will also not certify. That's why in most of the cases, even Supreme Court also given judgment, this particular 3C is only directly not mandate. Such other information as may be specified. An operational creditor initiating CARP may propose a resolution profession. That is also there. And once this is over within 14 days, they admit the claim, particularly if the application is complete or the no repayment was happened or no has been delivered to the operational creditor, invoice and notice payment of the corporate debtor has been delivered by him and no notice of dispute and there is no disciplinary proceedings, then only the application will be admitted by. For rejection of such communication operational creditor, the application made under incomplete, they will reject, and has been repayment, they will reject, and not deliver the invoice and for payment, no rejected, disciplinary action against the IP rejected, and before rejection, all these things they will look into. Once that is there, then they will admit the case. Hence, pre-existing disputes are to be verified thoroughly. Actually, in this case, the NCLT not verified properly. That's why the operational creditor filed an application with NCLT. Change in management is not the is a internal matter of the corporate debtor, and which the operational creditor has no role to play. And change management of the corporate debtor cannot be a ground for extinguishing or wiping off the past liabilities that owed to the operational creditor. So this is in brief about this case, and that's why whenever the claims admission is there, you have to verify the claims thoroughly, and once with the available records, with the available documents, or some other transactions are in the computer system, verify that one, or if at all any financial statements, the cross-checking is there, that is also to be done. Then only the cases are to be admitted. Otherwise, later on, it will create problem. But in this case, the role of IP or IRP is not there. The NCLT himself, they have rejected the claim, even though the claim is eligible for admission, and the NCLT has given direction to the NCLT to re-verify that one, and accordingly they admitted the case. This is in brief about today's class, sir. Any doubts up to this point? Any clarification, sir, on this case? Sir, any clarification? Sir, any clarifications are required? Any discussion? Madam?
Sir?
If at all there is no doubts, nothing, then we will wind up.
Anybody has any questions? Sir, now we shall conclude, I think.
Madam?
I think we should conclude now because
Okay. So
Thank
shall I
you so much,
close?
sir.
Shall I?
On
Sure.
behalf of all the participants in ICSI IIP, we are looking forward for more programs with you. Sir, you are requested to please share your PPT.
Okay, madam.
Yes, sir, please. That's very important, please.
Okay, madam.
Yes, sir.
Thank
Okay,
you very
sir.
much.
Okay, sir. Thank you, sir. All the best to all the professionals. And once again, wish you a happy and prosperous new year, particularly from the professional side also. Thank you, sir. Thank you, madam.
Thank you, madam, also.
Thank you, sir.